two purposes behind this. One is we want to try and help, especially those of you who have clients that are corporate clients that may be interested or may have bankruptcy problems, so that you know where to send your clients. Send them to Gary if they've got creditor problems, send them to me if they have debtor type problems. But the whole idea of doing this for the firm is to engage you and your clients, because we think there's going to be more of these bankruptcy situations happening in the future that will affect businesses and individuals. And we don't do a lot of individual bankruptcy stuff, but we do a ton of business related bankruptcy things, as well as representing individual shareholders or individual lenders in bankruptcy cases. Second purpose is try and get some associates that are involved. If any of you partners have associates that are underworked, we're going to give you an opportunity to send them our way to give them extra hours, because we have all kinds of work that can be done, from the corporate side, M&A side, drafting plans and disclosure statements when necessary, to just collection work, creditor work, debtor work, and understanding it. So a large part of the program is about that for you all. And the most important thing in terms of what we need feedback on is feedback on the program. On March 22nd, we're going to be doing this program for the Association of General Counsel. Audrey tells us that we have 22 general counsel signed up to watch the program. So if you think that there is something that we can improve on, something that we have done wrong, something that we can change to make better, let us know. All kinds of criticism is welcome, and if you've got any, please give it to us. Title of the program for the general counsels is Corporate Counsel in Bankruptcy in the Pandemic Era and More. It is about what is happening now and what is going on with bankruptcy work in the present moment. The beauty of this program is that we're talking a little bit about what the extra slides are at the end. For those of you who may be interested, associates like Leanne, Alex, people that are coming on, a lot of bankruptcy work in terms of how to be a bankruptcy lawyer are the slides at the very end. They're the yellow on top, green on the bottom slides. And for any of you who might be interested as associates in terms of learning about bankruptcy law, that's there at the end. Basically, we're going to talk a little bit about some of the landmines and divide the lectures up into pre-filing and post-filing issues. And the reality of it is bankruptcy is a very significant legal issue, but you have to understand that you have to prepare. And certainly for corporate clients and general corporate counsel, there are issues that are out there and landmines that are out there that can be prevented with advice from the two of us. One of the things that we've noticed about the pandemic is that for business clients that you may have, whether it's a charter school that's doing business with people who are selling them goods, the big box stores that may be going out of business, or their customers in terms of who they are, landlords in terms of who they are renting from. People are having problems all over. And so for the general counsel that we're going to be talking to, the look backward at their suppliers becomes extremely important, particularly with inflationary pressures happening, particularly with interest rates going up, and the supply chain problem that they've had. So our audience on March 22nd is going to be dealing with their suppliers and the problems that their suppliers are having. But on the other side as well, if you have a seller of widgets and that widget seller doesn't get paid, he's going to have problems on the consumer side and who he is selling to. So bankruptcy today is going to expand with inflation, with interest rates, with the price of gasoline, with the price of wheat that's going up. And that's a problem that we want to talk to general counsel about. And in your client base and for your clients, whether it's intellectual property, whether it's, like I say, charter schools, whether it's M&A deals, these kind of issues are going to be happening because this is an ever-changing world with the pandemic. And as government assistance programs drop off the map, it becomes even more important for general counsel and certainly lawyers to understand what's going on. Gary, have we seen this before? What do you think, huh?
Yes, been there, done that.
Yeah. Just to let you know, Gary and I have been practicing since 1980, 81, 82, in that era. And in the era of when we started this bankruptcy gig, when I did anyway, it was the same kind of trilogy that we're having right now, which is interest rates on the rise from the Carter administration, inflation going crazy. We didn't have the supply chain problem back then, but we certainly did have gas issues and gas lines, and that's getting started now. The whole idea of this program then is to try and help your clients be prepared, and more importantly, help some of those clients that we hopefully will be able to garner on this March 22nd program. Gary, do you see any similarities between what we went through in the 80s and then back in the early 2000s and today?
Yeah, except for the bank failures. That came a little later, but and that may happen here too. But you know, I'm not sure it's as doom and gloom, and you know, there seems to be a lot more controls in place as far as the inflation goes and the interest rates in particular. So we'll see if that kind of tamps things down. But I think the supply chain issues are a new factor that will be a driver for much of this, which all the more reason why at least suppliers of goods and services as well need to be very, very careful.
First question that all of our clients should ask themselves is, what am I? Am I a creditor or a debtor? And find out what that is. Because if in the world of today you are both, you are both. Sometimes you are going to be owed money and sometimes you will owe money, and trying to mix that balance is what needs to happen. So when you are sitting there with a particular problem, you need to understand the first question. Am I the party that's going to owe money? Am I the party of this equation that owes money? And if you understand why bankruptcy exists, you can get a little flavor for that first question. Bankruptcy didn't exist to protect debtors. Bankruptcy existed in the very Middle Ages to protect creditors. When the publican was going under, he paid the beer vendor because the beer vendor was his brother-in-law. The bread vendor said, wait a minute, what are you paying that guy for when you're not paying me? Debtors' rights didn't become a thing until after 1898, when Congress enacted the Bankruptcy Act to give debtors a discharge from debts if they were honest, honorable debtors. The reality of fights in bankruptcy are that there are bigger fights most often between creditors searching for the limited supply of debtor assets than there are between debtors and creditors. Although there is enough hatred to go around when a creditor gets stiffed and doesn't get paid. There's even more hatred to go around when that debtor files bankruptcy and the trustee in bankruptcy that gets appointed after conversion comes to the creditor and says, you know that money you got within the 90 days of bankruptcy? Yeah, I know you're still owed $1 million, but you got a payment of 300 grand within 90 days, the preference period. Give it back to me, and has the right to do that. So understanding that, yes, debtors do have rights. They get a discharge if they're an individual. They get relief from the claims that are against them. They get an opportunity in Chapter 11 to restructure their debt. But the reality of bankruptcy was, and really is, fights among creditors. Creditors seeking payment of limited pot of resources. Creditors trying to prevent other creditors from getting too much, or the debtor from absconding with assets, and basically serving as a protective device in terms of what can be done. With respect to bankruptcy, it's all about timing. The pre-filing period, if you're a corporate organization, you need to understand that if you're going to be on the debtor side, you need to get this started early. You're going to have to cash your retainer for a big debtor's retainer for your attorneys. But if you're a creditor and you're seeing what I call the runaround in terms of delay, you have to anticipate that there might well be a filing. And so the pre-filing period matters in terms of creditors from protecting themselves, and we're going to give you some hints on that. Once a filing happens, we're going to talk about what entities need to do that are asking for money or that are creditors, and we'll talk a little bit about some of the post-filing issues that matters. In terms of the landmines before what happens to bankruptcy, and Gary's going to talk extensively about security interests. There are two things that you have to watch out for if somebody is going to file bankruptcy on a particular debt that your client has. One, the recommendation is get secured if you can be, and make sure that you are perfected secured. The second is avoid preferences by trying to cash your checks or cash payments in the ordinary course of business as soon as they're received. Don't have that small business owner that puts checks in the desk drawer for a while and lets them sit there. That's where preference problems come in. In terms of filing, what we're going to talk about are proofs of claim, and Gary's going to discuss reclamation claims because not a lot of people think about those things. And then post-filing issues, the automatic stay in bankruptcy, we're going to give you some warnings. We'll talk a little bit about if you are secured, how you can protect your cash collateral, and what might happen in the Chapter 11 plan. The big bulk of bankruptcy centers around Section 541. What is property of the estate? Property of the estate is everything that a debtor has an interest in. Just assume that whatever it is, it's the debtor's, it belongs to the estate. And even if the IRS takes it, it can be brought back in. Even if it has escaped the debtor's grasp because the debtor made a payment, under preference theories, it can be brought back in. Even if the debtor hid it in his backyard or her backyard, it can be brought back in. Securitization matters, workouts matter, and money matters. Section 541 is about property. Gary?
I was going to just jump in and say, even if it's a deposit that's being held by a landlord or some other third party, unless it's a true escrow, which is why escrows and having some third party situation, a guarantee, a letter of credit, excuse me, some third party device or procedure to get that asset away from the debtor's asset, which would be, as Bill said, sucked into the bankruptcy under 541.
And Victor, it also applies to intellectual property. If you have a license to use property, if you have a license to use a copyright, that is a property interest which becomes property of the estate, and how that is treated as an executory contract matters. So we're talking first about security. Pre-petition, you have to document your debt. You have to perfect your security interest. You have to value the security, and particularly for intellectual property, where the securitization happens matters. And at our firm, I'd say talk to John C. Lee, because he is the expert on security. He does the UCC stuff very, very well. We've had instances, however, where there is an intellectual property dispute about trademarks, licenses, and do you securitize and perfect that security interest at the USPTO? Do you securitize it at the state of incorporation of the debtor? Do you securitize it at the state of incorporation where the property is located? One of the great all-time bankruptcy cases that I ever read and teach in the JD class is a case called In Re Zaptaki. And Zaptaki was a situation where in Ohio, a mortgage was issued. But unfortunately, Ohio law at the time said you need two witnesses to witness any interest of a transfer in real property. And this mortgage only had one witness. And so this bank goes into this case, feeling like they're happily secured. And the trustee looks and says, wait a minute, you only had one witness. And so a trustee avoided the lien. So in terms of security, make sure that your documents are correct. Make sure that your clients perfect their security interest. Make sure you have some kind of valuation, because what is important in bankruptcy is that you are an oversecured creditor, so you can claim post-petition interest, fees, and costs. But very critically on the perfection issue, make sure your security documents are either filed or recorded in the right place. Gary, what about Article 9 securitization?
You stole most of my thunder, but no. Actually, speaking of John Lee actually prepared this outline for another presentation that he and I did in the depths of COVID a couple of years ago. And we'll go through this fairly quickly because, you know, these are fairly standard items that I think most of you all know about. But the key, there's a couple, 3 steps to making sure you have, in fact, a security interest. One is you actually create the darn thing. And in order to do that, you have to have value given. You must also, key, of course, is that the debtor, the borrowing party or whoever is taking that credit has value, or excuse me, has an interest in the collateral itself. And you have to have a signed document. And the signed document generally is a, quote, security agreement, but it could be another document. But it's got to have the grant language, and the magic grant language is debtor hereby grants to secured party security interest in the collateral, and the collateral is very specific, very specifically described, and it's obviously signed. So whether it's authenticated, excuse me, whether it's an actual security agreement or not, it has to be the document with the grant. Next, once you've created it, you got to perfect it, which Bill already pretty much went through. It's got to be recorded, and for most types of collateral, it is recorded as a UCC-1 financing statement with the Secretary of State where the debtor is formed, if it's a corporation or an LLC. Once filed, the UCC financing statement then becomes notice to the world, and that's really the key. But key in bankruptcy is perfection. And as Bill has alluded to a couple of times, and we'll get to here pretty quickly, this is the minefield that trustees in bankruptcy or debtors in possession in bankruptcy want to attack as being a defect in the secured interest, that it wasn't properly perfected, it wasn't recorded with the USPTO and a UCC-1, if it's intellectual property, that type of thing. And so this is the ultimate pitfall where a secured creditor becomes an unsecured creditor, or their security becomes invalid. So next slide. Priority is your usual first to file, and that's pretty much the standard. So as between competing security interests, who's on first? As between an unperfected security interest, because they failed to do something we mentioned earlier, it's whoever's perfected, no matter what time. The perfection of control is a different issue. If it's something that has to be actually held by the secured party, then that would then trump, if you will, a bad word these days, that would have priority over a perfected security interest. It's not held by the secured party. Next. Purchase money security interest. This throws a little bit of a wrinkle to what I just said a moment ago, which is first to file. A purchase money security interest is just that. It's the provider of goods who basically provides the goods to the buyer, and even if that buyer already has, let's say, a blanket security interest on all of the buyer's assets, which is pretty common, the seller of those goods can come in and seek to have what's called a purchase money security interest, PMSI. And it's basically in goods, which is other than inventory or livestock. We'll come back to inventory in a moment, and has priority over any conflicting security interest if certain things are done. And the key to this is timing. Next slide. Which is that it must be perfected by the PMSI holder. The goods have to be identifiable, inventory or equipment that are subject to the transaction. There has to be a security agreement, et cetera, that we already went through. And in order to do that, and in order to then perfect and to give the notice, which is key to existing secured creditors of record, you have to do a UCC search. So advising sellers of goods to any buyer of goods, whether they hope that they're not going to go into bankruptcy, certainly they want to perfect that security interest. And surprisingly, this is often not done by major suppliers of goods. The UCC financing statement is effective for 5 years. And as to a PMSI, they can be continued just like any other security interest. But if the PMSI is in the debtor's inventory, then the new notice, which I think we jumped over, but the notice to existing lien creditors who have an existing lien must then also be provided to the holders of those conflicting security interests. All right, go for it, Bill.
Got it. Okay, so that's some things that you can do as telling our corporate clients that they need to do. Get as perfected as they can, make sure that if they have debtors that are out there that owe them money, they get a perfected security interest. And particularly if your clients are sellers of goods, that PMSI trumps other security interests. So if they are sending goods on the eve of bankruptcy and have one of these PMSIs, as long as they give the required notice, it helps them. But now we'll talk about what happens when that doesn't occur. What happens when it doesn't occur is that you get into what I call the 540 issues in bankruptcy. And the bankruptcy code's divided up into various chapters, but the hard money sections for creditors are 540 through 549 and 552, because those are the sections that a trustee in bankruptcy or a debtor in possession, which is denominated as a trustee in bankruptcy, can come back to their creditor and say, give it back. Turnover is automatic. If you have a creditor that is holding a debtor's piece of property, the debtor says, give it back to me, you got to give it back. Those are the 540, 541, 542 sections. The real rubs for a lot of clients from international clients, preferences, fraudulent conveyance, and just what is property estate. Property estate is everything that used to be ours within the two definitions of preference and fraudulent conveyance, period, and property that is ours no matter who it is held by and no matter where in the world it is held. So the preference, section 547, is a very important thing for some of your clients. They will receive letters from debtors' councils in Delaware. They will receive letters from the Southern District of New York. They will receive letters from Oregon or Washington. And those letters will say, hi, you got a payment within 90 days of the filing of the bankruptcy. And attached to that will be a schedule of when payments were made and when shipments were made. A preference is and that it would also include anybody that recorded a judgment lien or an attachment lien within the 90 days before the bankruptcy. A preference is any grant of payment to a creditor within 90 days of the filing of a Chapter 11 on account of an antecedent debt, meaning a debt that occurred earlier within 90 days or 1 year if it's an insider, that allows the creditor to receive more than the creditor would receive in a Chapter 7 case if the Chapter 7 case were to be filed in on a specific day, the date of the filing. Now, all of these debtors, the big debtors like Sears, the big debtors like Kmart, and the small debtors, all of them have this insolvency presumption on the date of filing because they're not going to pay their unsecured creditors pretty much anything. Most of them won't. So that test is always easy to meet. But what happens is there are banks of law firms and lawyers and accountants that just do this for a business, for the big bankruptcy entities. They go back to all of the payments that were made within a year of the bankruptcy filing, and they send these letters out. And your clients need to be prepared to get those letters. The two things I would recommend for clients and for general counsel: keep very careful track of when shipments happen and when payments are made. And second, keep very careful track to make certain that you are following your ordinary and business procedures with the contracts that you have with those debtors. And the reason is those provide the defenses that I've used, that I'm sure Gary has used, to try to protect against these preferential recoveries. If you are operating in the ordinary course, if you are operating and there are post shipments that are made, you have after acquired property that can be used as a defense to a preference, the idea is prepare by making certain you know when shipments of your goods or services were provided, you know when those shipments or goods were actually collected by you in terms of the payments, and you know that your collection efforts were within ordinary business terms, not just in the industry standard generally, but with respect to that particular creditor as well. So it's really important that clients of ours get paid on time, including us. I've defended the firm against a couple of preferential payment requests. I won't tell you which partners caused the problems, but it happens. So you have to get paid on time, and you have to make sure that when you get those checks, they get negotiated, because it doesn't, the preference period doesn't happen, the antecedent debt period doesn't happen when the check arrives or when the check is written, it's when the check clears. Just understand that if you delay collection, that's collection debt. And follow your contract procedures, that makes it important. Fraudulent conveyances, both pre and post petition, things to avoid. California is no longer a party to the Uniform Fraudulent Conveyance Act. California is a party to the Uniform Voidable Transactions Act, CCP 3439.04. We have to give you code sections in order for you to get academic credit. The best case that describes what a fraudulent conveyance is to me is this Mejia versus Reed case in 2003. It talks about what creditors will do and what the debtor will do to hide things that may create liability. Now, the significant thing is for our clients that are out there is that liability under the Uniform Voidable Transactions Act in California and liability under Section 548 of the Bankruptcy Code extends both to the transferor and to the transferee. So even if you think your client might be innocent, it doesn't matter, because somebody's going to come along and say, wait a minute, they were in league. And by being in league, that creates not just a statutory claim, but also can create a tort claim. And that tort claim extends liability to both the giver and the recipient. And in bankruptcy, the fraudulent conveyance claims are under 548. Particularly be wary if the payment happens to be made to an officer, a director, a significant shareholder, or the relative of an officer, director, or significant shareholder. Well, I just wanted to pay my mom back because she lent the money to the company. I just wanted to pay my sister back because she was the one that allowed us to buy the goods or services. And more significantly, watch out for guaranteed debt, because oftentimes money that is guaranteed can be viewed as a preference to preferential payment on behalf of the individual guarantor of the corporate debt. So those are kind of questions that when these issues might crop up for your clients, you need to ask. You need to ask, was any of this debt personally guaranteed by an officer, director, or insider of the company? You need to ask whether or not any of this debt is owed to an insider or a relative of an insider. And the key ingredient in defending against these is that fair and adequate consideration was given for the payment, because that really and truly in the area of fraudulent conveyances is your only defense. If there is adequate consideration given for a payment, then that can be a defense to a fraudulent conveyance. So both preferences and fraudulent conveyances overlap the pre-filing period, the filing, and the post-filing period, because that's when many of these get first litigated. So in terms of,
But always take the money.
never turn it down. But in terms of advising clients to be very cautious, some of the discussions that your client does not need to have with debtors is anything that would indicate an intent to hinder, delay, or defraud other creditors from getting paid. Anything that might have an effect of receiving less than fair consideration. I'll give you $2 million, but you only gave me $50,000. Anything that would leave a debtor insolvent might be something to ask about or left with inadequate capital. And if there is any transaction involving insiders, be very cautious about payments being made either to the insider or on behalf of the debt, which the insider may have guarantored. So those are some of the early things to watch out for if a company's debtors are likely to be filing. Prepare by having the security interest, prepare by watching out for fraudulent conveyances and transactions, prepare by protecting yourself by acting in the ordinary course on ordinary and reasonable terms. But that's the pre and the post petition. Now we'll talk a little bit about what happens on the filing date. On the filing date, general counsel for corporations must make decisions. And some of these decisions are very important to make. Gary just got a big case that we had a judgment on out of Alabama that we've been enforcing in California with a California bankruptcy case today. He's gone back and forth with the client about a $750,000 judgment. Do we file a proof of claim? Gary, what do you tell our client about filing that proof of claim in Los Angeles?
I generally say absolutely. What Bill's getting at is that by filing a claim in bankruptcy here, and the judgment creditor or the client, if you will, is in Alabama, they are subjecting themselves, the Alabama party is subjecting itself to the jurisdiction of the bankruptcy court. The alternative is you get nothing out of the bankruptcy because the claim was scheduled as being disputed. And if a claim in bankruptcy or a schedule of a claim or obligation is scheduled as being disputed, then it's up to the claimant to then file a claim. So you have a Hobson's choice of get nothing or potentially get something out of the bankruptcy, which is likely in this case, so we think. And if you don't file the claim, or if you do file the claim, then you're subjecting yourself to the bankruptcy court jurisdiction here. The jurisdiction of the bankruptcy court is pretty long and pretty far in any event. And back to the preferences, I was going to jump in. If the amount in play is $25,000, I think it's still $25,000, Bill, or more, you can get sued in Delaware. Or conversely, this bankruptcy here, the client could be sued here, the Alabama client could be sued in California and be forced to litigate that claim here. So the stretch of the long arm stretch of the bankruptcy court's jurisdiction is pretty far in any event. And so I think that the short answer is absolutely file a proof of claim. If you don't, you're not going to be participating in the bankruptcy.
And the one thing that lawyers do to protect themselves is also tell their client that filing the proof of claim may waive your right to a jury trial. It's the subject of like 6 or 7 Supreme Court decisions, but that tells you how big some of these cases must have been to get those issues to the Supreme Court. But in the interest of protecting against malpractice claims, well, you never told me I could lose my right to a jury trial, and I really wanted a jury. We tell the client in advance that filing the proof of claim might subject them to jurisdiction, and they might lose the protection of a jury trial if they want one.
So just one more comment I was going to say, and this is, I think I've commented to a number of the litigators that, and this is bear in mind, this is by a bankruptcy practitioner, and Bill probably has said it too. Filing bankruptcy was actually a favor to you, the client, in this situation, because now that trial you were going to be preparing for in 6 months or a year, now you file a proof of claim in the bankruptcy. And to the extent it's litigated, it's litigated in the bankruptcy, or you can always seek relief from stay, which Bill's going to get to here in a moment. But you have that option, especially if litigation hasn't even been filed yet. You file the claim, and the default on the claim is it's actually deemed to be allowed unless it's objected to. And it's deemed to be valid unless it's objected to. So takes some money out of the litigation litigators' pockets, if you will. In the event of bankruptcy, it shortcuts and allows the claim to be really deemed to be allowed and not even litigated in the bankruptcy if that's how it goes down.
And that's the beauty of it. You get prima facie validity as to both amount and liability by filing the proof of claim. Bankruptcy, I've often talked to the classes that I teach, is about giving and taking. What the bankruptcy code gives to creditors is you file this proof of claim, it's prima facie valid as to validity and amount. What bankruptcy takes away is the debtor can object, or any creditor can object to your claim, and that means that the litigation is going forward in bankruptcy court without a jury. So you get, hi, I got my claim, you give up, hi, if they dispute it, I don't get a right to a jury on the dispute. Okay, the biggest thing for your clients to know is once a chapter petition of any type is filed, stop. The automatic stay is very significant. It is very important. It prohibits writing letters. It prohibits collection actions. It prohibits dumping garbage on a debtor's lawn because you're irritated at the debtor that they didn't pay you. The automatic stay is automatic. It's an injunction that operates by statute. It doesn't need extra litigation to have happen. If you get wind of a petition in bankruptcy, stop. Because bad things do happen to people who violate the automatic stay, especially those who violate the stay willfully. And those damages that are in favor of the debtor, even though the debtor and a creditor can be injured by reason of the violation of the automatic stay. And if it's an individual creditor, that individual creditor under Bankruptcy Code Section 362K can get punitive damages. So the creditor that is owed money does something that violates the stay, the bankruptcy judge slaps their hand and says, hi, you pay the debtor money or you pay the creditor money for your violation of the stay. You get a bankruptcy notice, stop. Call Gary or me, or hopefully one of the associates that's listening that will want to have a well and fulfilled career from here forward as a bankruptcy lawyer. Proof of claim. We talked a little bit about what the proof of claim does. It's bar dates. The first thing that we should do whenever we get wind of a bankruptcy case is we need to look at the docket, because on the docket will be the dates for filing proofs of claim. The date is fixed every once in a while by court order separately from automatic fixing or filing. But in certain cases of Chapter 7 bankruptcy cases, it's fixed from the first date set for the first meeting of creditors under Bankruptcy Code Section 341. And so those bar dates for filing claims or the bar dates for filing non-dischargeability action are tied to the filing date of the bankruptcy case, and in certain instances are tied to the very first date set for the first meeting of creditors. But real important, once we find out what the bankruptcy case is, get a copy of the docket off Pacer. The dates will be put on there if they are established. Schedules and statements. You should advise your corporate clients and their counsel to go ahead and look and get the schedules and statements that the debtor filed. This case that we're talking about on the Alabama thing, Gary made great use out of the schedules and statements in examining the debtor at the 341A examination. Those schedules and statements are filed under penalty of perjury, and so they provide evidence of everything the debtor has done, or they should, of everything the debtor has, of every debt claim the debtor's paid, and of everything the debtor has done in the 90 days, or sometimes even 3 years before the filing of the bankruptcy. Schedules and statements, usually docket entry number 1 or somewhere in the first 10, must be filed within 14 days of the filing of the petition unless the debtor gets an extension. look for them and see if we need to be appearing as special notice. The beauty of bankruptcy law now is that everything is online filing. We can get ECF filings. It's real simple. Everything that does get filed after we file a request for special notice is ours. And then Gary talked extensively about the creditor's dilemma. You don't file a proof of claim, you don't get paid, but you do give up ambush jurisdiction. Gary, anything else on the proof of claim that we need to talk about?
No.
All right. That gets us to another way that creditors can protect themselves after the filing and maybe get their property back.
Right. And this is one of those deadlines that Bill was alluding to. Once a bankruptcy is filed, it triggers a number of deadlines, proofs of claim, et cetera, as Bill already mentioned. And this is a big one here, which is a seller of goods. You can tell I'm sort of focused in on the provider of goods to a now debtor in bankruptcy. Has a right, and this is our hypothetical, we basically have $100,000 debt, $50,000 of which are for unpaid goods that were delivered 45 days prior to the bankruptcy, and the other 50,000 were within 20 days of the bankruptcy filing. And so your client comes to us and says, wow, what do I do? They filed bankruptcy and they've got all these goods and I haven't been paid. And so the short response to that is we must file a reclamation claim, submit a reclamation claim to the debtor because we have very specific rights, and that has to be done. And this time starts running within 20 days after the bankruptcy filing, and no later than 45 days after the goods were delivered, if prior to the bankruptcy. So bottom line here is that time is crucial. Next slide. The reclamation claim is just that. It's a right to reclaim as to these goods delivered within 45 days, those goods, and just say, give them back, you return the goods. And this is consistent with provisions under the commercial code as well, as far as an insolvent buyer debtor. But you have a right to claim those goods. Now, does it happen? Do you get the goods back? Probably not. The goods are probably in process of being sold or something. And so that gets back to the PMSI that we talked about earlier, as far as at least a security interest in the proceeds from their sale. The other 50,000 in our hypothetical were goods delivered in 20 days. We have a right to the client has a right to get paid for the value of those particular goods. And the reclamation claim is pay us for the goods that were delivered within 20 days of the bankruptcy filing. And that claim, again, it's a claim, they don't have to get paid immediately. That reclamation claim for the $20,000 for the $50,000 within 20 days for those goods is an administrative claim that has the same priority as post-bankruptcy claims. And that's the whole purpose of this. The purpose is that it's unfair for a supplier of goods whose buyer becomes a bankruptcy debtor should be penalized for actually trusting the debtor and continuing to provide goods. Whereas literally moments after the bankruptcy, if those same goods were delivered, those goods would be entitled to payment as an administrative claim if they're not paid. So this levels that playing field. The reclamation claim, again, we've already talked about the timing. That's key here, and that's really the key for all of these bankruptcy issues. And I don't mean to even claim that this is anywhere as complex as tax, but just as in tax world, if you hear the bankruptcy world name, then you should really contact someone like Bill or me, just because these deadlines. And these deadlines, when they go, they can't come back. They're gone. Proofs of claim, if that deadline goes, it's pretty hard to undo that. You can try and you can make application to do it. And if there's a 100% plan where everybody gets paid, maybe it's not going to make a big deal in the long run, but that's a rare situation. So comply with these deadlines. I think that pretty much takes care of it, given our time, Bill, on reclamation.
And then we talk about adversary complaints. Gary?
Well, as to this proceeding, if you have, as I said, you have this reclamation claim, but the debtor doesn't do anything, then you've got to bring an action in the bankruptcy in order to get the debtor to return those goods that were delivered within 45 days subject to the reclamation claim. Then the bottom line here is, again, always file a proof of claim, so that there would be a proof of claim for the $100,000. $50,000 would be this administrative claim for the goods delivered within 20 days that I already mentioned.
And then that gets us to operating debtors, because sometimes your clients will have leases, sometimes your clients will be lenders, and sometimes your clients will have property that is subject to a lease or a security interest, and the debtor will need to get permission of the bankruptcy code, of the bankruptcy court, to use, sell, or lease that property out of the ordinary course of business. So operating sections run from 363 to 365, and in particular, Code Section 363 on the use, sale, or lease of property requires that before there's any kind of use out of the ordinary course of business, the secured creditor must receive adequate protection, and the secured creditor is entitled to notice, and the debtor has to ask the bankruptcy court for permission to use property outside the ordinary course. In terms of 364 borrowings, the real rub here is, and some of your clients may be able to make money doing this, there are such things as what we call priming loans, meaning the debtor has a pre-petition loan to a lender but needs cash. A lender will come in and say, I will give you cash in the post-petition period, but I want a higher priority of lien against all of these assets that are currently encumbered. And the bankruptcy court, under the right circumstances, has the ability to elevate the lien of new lender above old lender. And that really makes some banks and financial institutions very, very angry. So if you get one of those situations, it might happen. And then finally, leases and executory contracts, and that would include things like licensing agreements, real estate contracts, options to purchase real estate. The treatment of those creditors is sometimes very valuable. So if your client is listed on Schedule G of the schedules and statements, that's the schedule for executory contracts, and they have specific rights that you need to understand need to be protected promptly in the bankruptcy case. So 365 issues. Gary?
Yeah. Oh, perfect. You got a slide even. So on the 365 issues, and again, it's timing. And we'll be advising, at least I advise mostly on this side of the equation, landlords for non-residential real property, commercial leases. And in that context, the debtor must decide whether to assume or to reject that lease. The bad news is that part of that assumption rejection process is that they can cure, meaning if they were 6 months in arrears or months in arrears before the bankruptcy, and the landlord was just about to get that judgment of eviction or unlawful detainer, this stops all of that because of the automatic stay, and the debtor then has a right to assume that lease if they pay all that back rent. Usually that's negotiated if it's a big box landlord with hundreds, thousands even of locations, that cure goes away pretty quick or gets reduced. And then there's the adequate assurance, which is that they'll be able to perform going forward if they do assume. Timing is key here. And this sounds actually like a long time, but these are pretty short times in the world of bankruptcy, is that the debtor, at least initially, for a non-residential commercial lease has 120 days to decide whether to assume or reject. Always, certainly in a large bankruptcy, big box type bankruptcy where there are many locations, they get an extension of that for an additional 90 days, but then it's over after 210 days. That's bad news for a landlord who hasn't been paid prior to the bankruptcy, but then during the bankruptcy, the landlord must be paid as you go. And there's certain depending upon if it's Delaware or a Delaware bankruptcy, if you will, or a California bankruptcy, how the landlord may be treated as far as pre-petition, post-petition. In Delaware, for some reason, they file on the 2nd of the month. And if they've got, Hawaii locations, then they file a certain time on the 1st of the month, to make sure that they are in the next month, because they basically get the whole month free, if you will, or at least they don't have to pay that as they went. Whereas in bankruptcy here, there would be a pro rata payment, so they can't file a bankruptcy. But the bottom line is, post bankruptcy, the debtor tenant must pay as they go. The alternative is rejection. They hand the keys over. They don't have to cure anything. You have a claim in bankruptcy then as a landlord, which is capped at basically 1 year of the rent. But that 1 year cap is just that, a cap. It's not a floor. And so the landlord still has obligations to mitigate, relet the premises. And if it does not, then it would be subject, that 1 year limited claim would still be subject to attack. I think that covers it, Bill.
And that gets us to what's happening in the world today is the small business Chapter 11. Chapter 11s became too darn expensive. So in February 2020, with COVID starting, Congress enacted something called the Chapter V or Chapter 5 Small Business Chapter 11. Right now, the debt limit is $7.5 million. If you have total non-contingent, secured and unsecured debt less than $7.5 million, you can be one of these small business Chapter 5, Chapter 11 debtors. But it existed because, and this is still true to this day, Chapter 11 for most businesses, too costly, too hard to figure out, and too complex. Too hard to figure out is you got to have an impaired consenting class agreeing to your plan. If you don't have that, you can't keep anything. And even if you do have that, you have to satisfy what's called the absolute priority rule. The small business subchapter 5 case gets rid of that. Acceptance by creditors are not required. You get 3 to 5 years to pay off your debt according to your plan. And any creditor that is owed less than $10,000, not creditor, any lawyer that is owed less than $10,000 on the filing date can represent the debtor. And this is a problem that I have run into doing debtors work. If Procopio is owed one dime by a debtor on the day of filing, we can't file the bankruptcy case because under a case called Knudsen out of the Ninth Circuit, we're conflicted. We are a creditor, and hence the firm cannot be a fiduciary to creditors because we are one of the creditors. But the big thing, as far as I'm concerned, because I think the U.S. Trustee's Office I think payment of U.S. trustee fees is a very added expense that's unnecessary to debtors that are struggling. This subchapter 5 thing saves those monies. You have a trustee, but the powers of the trustee are not that great. You don't have to pay for creditors committees. You have to get a status conference done within 60 days, and you have the exclusive right as your own debtor to file your own plan within the first 90 days of the bankruptcy case. The reason why it becomes important today is that on March 22nd, the limits that were extended from 2.5 million when this was initially enacted to 7.5 million on the debt side have to be extended. The sunset provision of the extension of the 7.5 extended till March 22nd this year. Congress thought COVID would be over by then. We don't know that that's the case, but if Congress does not extend that $7.5 million extension or debt limit increase, then it reverts back. So all cases filed March 23rd and after would be capped at 2.5 million in unsecured debt. And that really shrinks the numbers that will be there. So if Congress is not going to do this, look for a lot of subchapter 5 cases to be filed between now and March 21st. And the same thing is true with the PPP program, Build Back Better, some of those things, and of course the situation in Ukraine. are occupying Congress. So even with inflation and interest rates, it may be that Congress does not extend that deadline, in which case bankruptcy Chapter 11s are going to be real hard and expensive for people. So all of you know this. This is us. I would say, Gary, what are we missing, if anything, in our hour of need here?
I think we probably covered most and probably too much for one faucet to be full blast here as far as bankruptcy stuff. But this is a good overview. And as I said earlier, the concept is that if a bankruptcy is filed, especially for one of your clients, or unless you're an associate who really wants to do this, I don't know why you would, but unless you want to do this, come talk to us one way or the other, because there really are some, as Bill said in one of his initial slides, there are some serious landmines. I think the balance of these 20 pages are all the how-tos and the like of bankruptcy that you put in here, Bill. It's probably your teaching syllabus.
And that's a large part of it. So any of you who might be interested in a wonderful, meaningful career of helping deserving debtors, come see me, because I will teach you how to do this. And these slides that follow should be helpful for you and for general counsel. And we're going to give the program materials out like this. We'll stop the program on the 22nd, where we just finished with our ID stuff. But we're going to give them all this, because what we're going to do is we're going to tell people how bankruptcy works, and what I will help you with if you want to learn how to do bankruptcy is try to explain some of the terminology. What I will help you with is explaining where bankruptcy comes from as a constitutional matter, as a statutory matter, as a judicial process, and what the system really is, because more cases have gone up to the United States Supreme Court about bankruptcy jurisdiction than anything else. And the first case that went up there broke my law professor's heart. I learned bankruptcy from a gentleman named Frank Kennedy, who was head of the Law Revision Commission that changed the bankruptcy code on October 1st, 1979. And his big thing, along with the Chief Justice of the Supreme Court, was to make bankruptcy judges real judges. And to do that, they created the bankruptcy judge system. And the United States Supreme Court decided that that was not right. And when I brought Professor Kennedy out to talk about all of these cases in terms of what was happening with bankruptcy court jurisdiction, he told me that his heart was broken because his life's work from 1975 through 1979 ended. And I asked him if it really ended in the spring of 1980 when he had a class full of dummies like me, and he said no. He liked that class because he said there's not a book that you need to buy because everything's going to change. And certainly in October of 1979, everything did change, and the system became a very good system until the U.S. Trustee's Office got involved. So that's our hour. We're done. If you want to learn more about it, you will see these yellow and green slides. Take a look at them. We'll make sure you have them. And if you want to learn anything about bankruptcy law, that's kind of where we'll do it. And Gary and I need all the help we can get. I think going forward, there's going to be a lot of new bankruptcy stuff that's happening, and the law is ever evolving. So thank you all for sticking with us and being here. Audrey, I think we're done.